We are currently at the NAACP, or National Association for the Advancement of Colored People's Wartime Conference, where Thurgood Marshall will be delivering his speech urging the members of this organization to fight for their rights as citizens of these United States. The day is July 13th, 1942. I welcome Judge Thurgood Marshall to speak to us.
Thank you, sir. My speech is regarding the legal attack to secure civil rights. On last night we heard a clear statement of some of the problems facing us today. My job tonight is to point out a part of the general program to secure full citizenship rights. The struggle for full citizenship rights can be speeded by enforcement of existing statutory provisions protecting our civil rights. The attack on discrimination by use of legal machinery has only scratched the surface. And understanding of the existing statutes protecting our civil rights is necessary if we are to work towards enforcement of these statutes. One legal treatise has defined the subject of civil rights as follows. In its broadest sense, the term civil rights includes those rights which are the outgrowth of civilization, the existence and exercise of which necessarily follow from the rights that repose in the subjects of a country exercising self-government. The 14th and 15th Amendments to the Constitution are prohibitions against action by the states and state officers violating civil rights. The NAACP and its staff made repeated requests and in many instances filed detailed statements and briefs requesting prosecution for lynch mobs, persons guilty of peonage and other apparent violations of the federal statutes. It was not until the administration of Attorney General Frank Murphy that any substantial efforts were made to enforce the civil rights statutes as they apply to Negroes. Attorney General Murphy established a civil rights section in the Department of Justice. Our civil rights as guaranteed by the federal statutes will never become a reality until the U.S. Department of Justice decides that it represents the entire United States and is not required to fear offending any section of the country which believes that it has the God-given right to be above the laws of the United States Supreme Court. The most important of the civil rights provisions is the one which provides that every person who, under color of any statute, or ordinance, regulation, custom, or usage of any state or territory subjects or causes to be subjected any citizen of the United States or a person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity or other proper proceeding for redress. Under this statute, any officer of a state, county or municipality who, while acting in an official capacity, denies to any citizen or a person within the state any of the rights guaranteed by the Constitution or laws is subject to a civil action. This statute has been used to equalize teachers' salaries and to obtain bus transportation for Negro school children. It can be used to attack every form of discrimination against Negroes by public school systems. The statute has also been used to enjoin municipalities from refusing to permit Negroes to take certain civil service examinations and to attack segregation ordinances of municipalities. It can likewise be used to attack all types of discrimination against Negroes by municipalities as well as by states themselves. It should also be pointed out that many of our friends of other races are not as loud and vociferous as the enemies of our race. In northern and midwestern cities it repeatedly happens that a prejudiced southerner on entering a hotel or restaurant, seeing Negroes present, makes an immediate and loud protest to the manager. It is very seldom that any of our friends go to the managers of places where Negroes are excluded and complain to them of this fact. Quite a job can be done if our friends of other races will only realize the importance of this problem and get up from their comfortable chairs and actually go to work on the problem. Thus it seems clear that although it is necessary and vital to all of us that we continue our program for additional legislation to guarantee and enforce certain of our rights, at the same time we must continue with ever-increasing vigor to enforce those few statutes, both federal and state, which are now on the statute books. We must not be delayed by people who say, the time is not ripe. Nor should we proceed with caution for fear of destroying the status quo. Persons who deny to us our civil rights should be brought to justice now. Many people believe the time is always ripe to discriminate against Negroes. All right then, the time is always ripe to bring them to justice. The responsibility for the enforcement of these statutes rests with every American citizen regardless of race or color. However, the real job has to be done by the Negro population with whatever friends of the other races are willing to join us. Thank you everyone for giving me your time today and listening to what I have to say. I say that we must begin our legal fight for civil rights. Only when we begin to do so will others follow and come behind us. Thank you all for your time today, and goodbye.
Thank you very much, Judge Marshall. We have certainly been shown a new light, and we shall certainly act as you urge us to act. I now adjourn this wartime conference of the NOSCP. Thank you, everyone.